Okay, so comments made during the public comment section of the agenda will be limited to 3 minutes.
Got it.
You got it, yay.
Your mic is working?
Yes.
Okay. Mic 2, mic 1. We're good, Lisa.
That's good.
Yes, happy.
What's the mic number where the magistrate is sitting?
7?
7? I just want
Yes.
to turn all the others off.
Yes,
7?
thank you.
Okay. I'll just leave the trash master on for you.
Thank you. You're good? I put a water bottle there for you.
Yes, thank you very much. This thing will really come in handy. Like each year I go to a large dispute resolution conference, like 1,000 people. And it'd be nice.
Yeah. One of the girls that does the meetings, she wears it. She wears it. You get everything.
But I'm going to have to tell my hearing aid people
Yeah.
that
There's something else available.
something else available.
They probably don't want to offer it because they want to make that money off of whatever they're selling.
Nah,
No?
these are good people, but they may have just forgotten to check. You know, I told them to check, and they may not have.
It almost looks like remember the Walkman? It looks like a Walkman to me.
Yeah, sort of.
Uh-huh. All right, let me go check on something.
Testing, 1, 2, 3. Just one more time, I may have lost the channel.
So we're here today. Please speak directly into the microphone.
Yeah, I got it.
You got it?
Oh, perfect, okay. That
You got it? You can bring it down.
I think that should be a good height. And I'm not very tall, so.
Should I turn on the fans?
I'm okay.
Okay.
Do we have a new person today?
Yes. You do, it's me, for both of them.
Well, come up and let me introduce you. Okay. First, let me make sure I've got your name. It's,
Officer Lindsay Longstreet.
what's the first name?
Lindsay.
L-I-N?
D-S.
E-Y? Longstreet.
Just like it sounds.
Okay, well, welcome.
Well, thank you. I'm nervous. These things always give me anxiety, so I'm gonna do my best to.
Just take your time. You'll do just fine.
Well, thank you.
Well, we don't exactly have a big crowd yet. Yeah, here comes someone. That's the police officer.
How you doing?
Morning.
Yes.
Okay, so look like that. How you doing this one?
Good, good,
Are you gonna be speaking today? Are you gonna
Pardon?
speak? Are you gonna speak
Oh,
today?
yeah.
So I need you to fill this up, right?
Oh, of course.
So that you're gonna fill it out.
Oh, yes, ma'am. Thank you.
And then just give it back to me.
Absolutely. This is ready for Christmas.
good. Trying to get there.
Yeah, going on a cruise and like,
Oh, wow.
so creepy.
Mr. Marcy, do you hear like a whistling noise? Do you hear whistling noise in the background?
No,
You don't hear what you were hearing before?
no.
Okay.
No, before it was an echo.
Like an echo?
Oh, yeah, it was like hearing things twice.
Okay.
And the beauty of this is with the earbuds, I can hear both with the hearing aids and,
You have a better brand.
Hmm?
You have a better brand.
But I had to be very, oh yeah, those things didn't fit me. These things, I have to be very careful on picking the earbuds.
Oh, excuse me, ma'am.
And it's Jason?
Yes, ma'am. Oh, here's your pen back. You got it off the minutes.
Jason, what's the last name?
Wheeler, W-L-R. G-L-E-R.
Thank you. We do have one more that's come in. We do have one more person that's come in.
Are we going to be speaking today? Are you going to be speaking today? Are you here for the code enforcement?
Good morning, ladies and gentlemen. Today is the December session of the Special Magistrate for the City of Oviedo. Today is December 5, 2024. The first case on the agenda today is case number CE 24-000404. The respondents are Darrell Davis and Donna E. Davis. The address is 1447 Twin Rivers Boulevard, Oviedo, Florida, 32766. The parcel number is 19-21-31-000-4300. Who's going to be speaking on behalf of the city today? And Mr. Davis, I see you're here. Would you step forward to the microphone? All right, would you both raise your right hand? Do you solemnly affirm that the testimony you shall give today will be the truth, the whole truth, and nothing but the truth?
I do.
All right, we'll start with you, Ms. Longstreet, and then we'll hear from you, Mr. Davis. You may sit down, Mr. Davis, till it's your turn. Right?
Good morning, Special Magistrate. My name is Code Enforcement Officer Lindsay
Is
Longstreet
that
with the City of
microphone?
Oviedo. Can you hear me? Good?
Yes.
Okay, sorry about that. Good morning, Mr. Special Magistrate. I'm Code Enforcement Officer Lindsay Longstreet with the City of Oviedo. I have a total package with 15 pages to submit into evidence. May I approach the bench?
Yes, you may. And has that package been provided to Mr. Davis? Right, and this is 15 pages,
Yes, sir.
right? This will be admitted as city's Exhibit 1 into evidence. All right, Ms. Longstreet, what do you have for us?
On July 10th, 2024, I had received a notice from the building department advising there was work completed at this property with no permit. I proceeded with the code enforcement process. Pages 1 through 4 is going to be the property record card showing that Darrell and Donna Davis still own the property as of today. Page 5 is going to be a photo of the shed from the building inspector. Page 6 is going to be a notice of violation that was sent with a corrective date of August 19th, 2024. Page 7 is the certified mail receipt. Page 8 is the signed green card. And then I'd like to note that on August 9th, the property owner had came into City Hall and spoke with staff advising the permit had been applied for at that time. However, we monitored the status due to the permit being rejected, so time was given for him to resubmit, but to no avail. Thus, a second notice of violation was sent, so that would be page 9, with a compliance date of October 3rd. Page 10 is a second notice of violation. Page 11 is the certified green card. Page 12 is going to be our notice of hearing. The property owner was given more time after the second notice of compliance date of October 3rd to obtain a permit, but to no avail. Thus, a notice of hearing was sent out on October 16th. And page 12 is the copy of that.
What seems to be the problem with getting a permit issued?
He, I believe, still had documentation that needed to be submitted that was not submitted.
But he did apply at one time.
And it was rejected, yes, sir.
Okay. When was that application?
I believe that was August 9th, somewhere around August 9th, he had originally applied.
Has he applied again?
Yes, sir, that was going to be part of my ending of the packet.
Okay.
If you don't mind waiting till then, or I can
That'd
explain.
be fine.
Okay.
Right ahead.
So page 13 was the certified mail receipt for the notice of hearing. Page 14 was the certified green card return signed. And then page 15 is just a photo of a reinspection that was done on November 20th as I was in the area assessing other violations. We stopped in to see if anything had been done with the shed at that time. Shed was still present, no permit at that time. And in closing, the property as of today has been found to be in compliance after much time, meeting, and conversations. The city is asking for this case to be duly noted on record in the event any of the same violations occur for repeat status if warranted. The city is asking for the administrative costs associated with processing this case be remitted to the city.
All right, so the respondent is, as of today, in compliance.
Yes, he has submitted the application, and this permit, the application is in the review process.
So what the city seeks today is a designation for repeat offender
Yes, sir.
status later. What admin costs are you seeking?
The city is seeking $500 for administrative costs.
And what does that include?
The administrative cost includes the time of getting the cases prepared, the times of inspections, the meeting times, everybody's time.
All right. I will enter an order reflecting that that all notices required by statute and ordinance were given. That as of today, the respondents are in compliance, but that any further violations would result in a repeat offender status. I am going to decline the request for administrative cost. Anything else to come before us today?
No, sir, not for this property.
Okay, thank you. Mr. Davis, you're here. You have anything you want to say?
Yes, I did meet with the building official. I also went to engineering trying to get a variance. The gentleman that I spoke to said that he found out he was on vacation, so he took quite a while to actually get back to me, and only to find out that that variance was the setbacks were actually, the rights were owned by AT&T and I believe Spectrum, so I wasn't able to do that. The code officer actually came to my home and I took her to the back so that they could actually see that no additional work was actually done. I actually applied for the permit just recently, and they kicked it back to me and wanted me to resubmit. There was two measurements on the document, on the survey. One was 5 feet and one was 10 feet. They highlighted the 5 feet, but what was actually on the actual document for where the shed is going to be located was actually 10 feet, and they kicked that back to me. I actually resent that back last night, so I'm actually now waiting to hear back from the building department.
All right, thank you.
Okay, all right, thank you.
All right, the next case on the agenda is case CE 24-000545. Respondents are Sherry Winkler and Marie Adams. The address is 1079 Covington Street, Oviedo, Florida 32765. Parcel number 23-21-31-503-0000-003. 3-0. Who's going to be speaking to that today? Right? All right, what do you have for us? Well, first, anyone else that's going to be speaking to this? All right, would you come up to the microphone? Would you both raise your right hand? Do you solemnly affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, we'll hear first from Ms. Longstreet, and then
Okay.
we'll hear from you. Thank you. Ms. Longstreet, what do you have for us?
Good morning again. I have another package I'd like to submit into evidence that has a total of 20 pages. May I approach the bench?
Okay, yes. All right,
On August 27, 2024, I observed a accessory structure in the backyard of the property that was erected with no permit. So the code enforcement process was started. Pages 1 through 4 are going to be the property appraiser's record showing Marie Adams and Sherry Wingler still own the property as of today. Page 5 and 6 is going to be a photo of the property and the accessory structure in the rear yard. Page 7 is a...
slow down just a moment here. The accessory structure, is it behind the house or beside the house?
Yes, sir, it's behind the fence in the rear yard.
Okay. Was it, having trouble seeing it in the photographs. Is it wood or metal?
It was wood. If you look at picture 6, the house is the left, and then right behind it, the stuff kind of jutting out to the side, the newer looking lumber, that would be the accessory structure.
So it's sort of attached to the house?
No, sir, it's not attached.
Okay. All right, go ahead, Ms. Longstreet.
Page 7 is a notice of violation that was sent to the property owner with a compliance date of September 27, 2024. Certified mail receipt is page 8. Page 9 is the return green card unsigned. Page 10 would be the photo of the reinspection on the 27th, showing that the shed was still there with no permit. Thus, page 11 is a second notice of violation that was sent with a compliance date of October 10th, 2024. Page 12 is the certified mail receipt. Page 13 is the return green card unsigned. Page 14 is the affidavit of posting. And page 15 and 16 are photos of the notice being posted on the property. Page 17 is a photo of the reinspection showing that the accessory structure is still there with no permit.
It doesn't look like it's completed, it's just the frame,
Yes, sir.
okay?
And thus, page 18 was a notice of hearing that was sent on October 16th. Page 19 is the certified mail receipt. Page 20 is the return green card signed. And in closing, the property as of today has been found to be in compliance. After much time, meeting, and conversations, we, the city, are asking for this case to be duly noted on record in the event of any same violations occur for repeat violator status, if warranted. The city is asking for administrative costs associated with processing this case be remitted to the city.
So it's now in compliance.
Yes, sir.
Yes. So you're seeking again repeat offender status
Yes, sir.
and anything else?
Just administrative costs.
Okay. All right, I will enter an order finding that they're now in compliance. I will decline to award administrative cost. Anything else to come forward?
No, sir. No, sir.
Okay,
Thank you.
thank you. Anything else to come before us today? Well, do you, is Mr. Davis? No, Mr. Wingler?
Yes, sir.
Do you want to add anything?
Actually, I think that's pretty much resolved it, really.
Okay,
So, yeah, there was some discrepancy on my knowledge on what it took to do it, so we just, and then the land variances, so now I just got to go back to the drawing board and get it done that way.
okay.
So we're good.
Thank you, sir.
All right, thank you, guys. Have a good day. Sir,
Thank you.
do I need something? Bless you guys. Have a good one.
Okay. While we, Miss Correa, Miss Moyer, Miss Longstreet, while we're all here, let me explain why I'm not rewarding administrative cost. I have researched the devil out of this. And the problem is there is an Attorney General opinion that that says in essence that I cannot award administrative costs for time and work spent by employees. In fact, Mr. Hall and I have been corresponding by email on this, and I sent him a lengthy email yesterday, but I'll sort of go through the gist of it with you. See if I can find it here. As much as I would like to, it wouldn't do me any good to have somebody appeal and tell us that we're wrong. In fact, I'll read it for you.
Thank you.
Mr. Hall, thanks for your email, but I continue to be concerned about assessing administrative costs in special magistrate hearings. The reasons are as follows. I understand administrative costs to include, one, money paid by the city to its in-house counsel, or personnel, clerks, officers, employees, etc., for work associated with prosecution of the case. Two, money paid for supplies and in-house equipment utilized in prosecution of the case. And three, fees paid to the special magistrate for his or her services. I don't read 162.02 as authorizing the assessment of administrative cost. That section authorizes the imposition of administrative fines and other non-criminal penalties, but notice fines and penalties. This language seems clearly to equate fines with penalties. There's no question that the special magistrate may impose fines and non-criminal penalties, but I don't believe we can equate fines and penalties with administrative cost. If the legislature had intended to include cost in this section, they could have done so. The fact that the legislature addresses cost elsewhere in Chapter 162 lends credence to the idea that it intended cost to be an animal separate and apart from fines and penalties. Sections 162.063 and 162.072 seem to be the only references to what can be called administrative cost. There are references to cost to repair in other sections, but these refer to situations where the city has undertaken remediation work on the violator's property. Section 102, Section 162.063 of Chapter 162 does seem to be the only subsection that unequivocally authorizes the imposition of administrative cost. This subsection deals with a situation where a repeat violator has been given notice of violation, a hearing has been scheduled, and the violation has been corrected by the time of the hearing. In this limited circumstance, because the violator is a repeat offender and because he has put the city to the expense of an unnecessary hearing, the city may schedule a hearing to determine cost and impose the payment of a reasonable enforcement fees on the violator. Even in this case, however, the subsection requires a hearing, quote, to determine cost, close quote. This seems to envision some sort of evidentiary hearing. That means probably the city would have to tell the special magistrate what costs there are, sort of to itemize them. But that's a very limited circumstance. Section 162.07 provides that, quote, if the local body prevails in prosecuting a case before the enforcement board, it shall be entitled to recover all costs incurred in the prosecuting the case. That sounds great so far. It sounds dispositive of the administrative cost, but for the Attorney General. The Attorney General's opinion, if you want to write it down, is AGO 2014-04. And I highly recommend you take a look at that, AG 2014-04. AG 2014-04 addresses two questions posed by the town of Windermere. First, the town wanted to know if the town could recover from a violator the cost paid to the town's special magistrate. Second, the town wanted to know if it could recover the cost paid by the town to the special magistrate's assistance in assisting the magistrate in the performance of his duties. The Attorney General answered no to both questions. The Attorney General noted that Florida Statute 162.071 requires that the local government shall provide clerical and administrative personnel as may be reasonably required by each enforcement board for the proper performance of its duties. The opinion says that compensation paid to public officers or employees for services rendered in the course of a case are not included within the term cost unless the legislature has specifically included them and the Attorney General could find no such authority. The Attorney General makes a distinction between costs paid to officers and employees versus costs that would typically be taxed in a court proceeding. Costs expended for items such as filing fees, reporter fees, witness fees, etc. The former are not recoverable, whereas the latter may be. In other words, if you spend money out of pocket for engineers, surveyors, third persons, then I think those are recoverable costs as I read the Attorney General's opinion. I don't think, though, that the time and money paid to employees and officers in prosecuting the case are. I realize that the AGO is not legal authority, but it seems to be the best guide we have at this time. I think an appeal court would most likely give it substantial weight. Therefore, I offer the following guidance for the city. Unless someone can show me some compelling authority to the contrary in a specific case, I will decline to award administrative costs as defined in paragraph 2 above. That's the one, officers, personnel's. The one exception would be the repeat offender situation. I will award hard or out-of-pocket costs paid to third persons. These might include fees such as outside engineers, outside photography fees, outside surveyor fees, witness fees, and other out-of-pocket outsider expenses made necessary for the violation. So because that mailed to him yesterday, it hasn't found its way to you yet. I do know that Ms. Moyer told me that some other cities are awarding administrative costs. All I can tell you, if they are, they shouldn't be. Give you that by way of explanation.
So, good morning, Mr. Marcy. So that was the reason why we included in our fee schedule the administrative fees, because
Well,
our
let me
code.
get my ears on here.
Oh, it's okay.
Okay.
So good morning, Mr. Marcy. So that was precisely why we included in our fee schedule the administrative, code enforcement fees, because our officers, Mr. Moyer, Ms. Longstreet, they go to the FACE conferences, and they've learned that other cities were doing that. And I think we thought that was a good option for the city, not only to recover costs, but also to not encourage people to leave the issue to come to the special magistrate,
Yeah.
right? So that would be a way for them to, there is an additional cost.
Right.
If you can resolve, because you saw the two issues today could have been resolved earlier, but people postpone and procrastinate, whatever, and they come here, and there is time and a cost involved in setting up the meeting. So we thought it was a good decision, but we are not attorneys. We will defer to you and Mr. Hall for
The problem with the other cities, they have two problems. First, I don't know if they're aware of the AGO opinion. And secondly, even if you were going to award cost, I think a special magistrate would have to have an itemization of what the costs were. Otherwise, he or she has nothing to base an opinion on. So I'm aware that some people are doing it, but I really think they're wrong.
Well, we will defer to you and Mr.
Yes.
Hall for sure to protect the city, right? We don't want to put the city in
I
any
don't want-
vulnerable position for sure. So we appreciate your research, and I'll check with Mr. Hall. I don't know if we have already charged, so I don't know if we have to do refunds, but I'll discuss with Mr. Hall about that.
Yes, well, Mr. Hall, I'd ask him for an opinion, and his opinion initially was that the subsection that provided that for the assessment of fines and non-criminal penalties authorized administrative cost. I simply disagree with Mr. Hall on that. I don't know if he had seen the Attorney General opinion or not, but the worst thing I could do for the city is to get somebody to take
Challenge,
start
yeah.
challenging your structure, and then other people come back and wanting their administrative fees back.
I understand,
Yeah.
so, yeah.
But what I'll do, I think I have Ms. Moyer's, I have Ms. Acosta's email. I'll send a copy of this email to Ms. Acosta, and she can give it to Ms. Moyer, Ms. Longstreet, and you, Ms. Correa.
For sure, and I will discuss Mr. Cobb, Brian Cobb, our city manager as well, so
Yeah.
that he's aware, because he ultimately he can make a decision,
Yeah.
not to,
There are other ways of covering it, and one way I cover it is in the fines. But I just don't think if we start calling it administrative cost, I think we have problems.
we understand, okay.
And,
Thank you for your research.
yeah, well, and again, do you have access to that Attorney General opinion online?
Well, I just copied
Yeah,
the,
it's readily available
Yeah.
online.
yeah, I'll,
It's a very interesting opinion. Frankly, I think that they're right, if you read the statutes.
okay.
Okay,
Thank you.
thank you, and welcome, Ms. Longstreet.
Thank